Okay, we started recording.
Thank you. So I am expecting it's going to be a kind of a collaborative and session rather than rather than a teaching. So I'll welcome contributions, during the talk. So I'm just going to describe a vignette or a scenario about a young man called Mr. Okafor. If there's any Mr. Okafor in the house, this is a fictional name. It's a real story, but the names have been changed, so nothing to do with anybody in this group. This is a 57-year-old man, a chartered accountant who has been married for 30 years and has 3 children. Unfortunately, his 29-year-old son, who's a lawyer, died suddenly of a heart attack when he was playing football. According to the customs of where Mr. Okafor comes from, you're not allowed, you don't bury your children. He wasn't able to, he didn't attend the funeral, nor this wife. However, over a few weeks afterwards, his wife, Mr. Okafor, calls the GP expressing some concerns about her husband. Also, since Chidi died, Mr. Okafor has been feeling low in mood, has been unable to sleep, has lost his appetite, there's been some weight loss, and he's been having sort of recurring nightmares and sweating profusely at night. So with this scenario, just want to think, leave you to the house. What do you think might be wrong with Mr. Okafor at this time? What do people think?
He might be depressed.
It's my depression.
Yes, he might be depressed.
He might be depressed, yes.
Yes, I would say that it's his way of dealing with bereavement.
Yes.
Yeah.
It could be bereavement. So I've got a Chidi in the house. Sorry, Chidi, it's nothing to do with you.
Well, I was just about to tell you that I just resurrected from the dead. But yeah, I think Mr. Okafor will be feeling also suicidal as well, right?
Yes, it could be feeling suicidal. Yes.
Yeah.
Yeah. So so at this occasion, I mean, what we think in mental health will probably Mr. Okafor is bereaved is showing normal grief reaction, which we could all sort of, which is the normal experience after the death. Next slide, please. And next one. Right. So so it's a normal feeling, as I said, following a loss. But this feeling, we expect it to be contained within 6 months. After that, then you start thinking, what's going on? Is there a disorder going on here? So it's very difficult to be able to predict how somebody will react once if an individual should lose a loved one. Some people will become sad and depressed, as we've heard. The reaction may be shock or absolute denial that death is taking place, or people can just not believe it. Some people will feel numb. There could be some form of panic and confusion. What do we do now? How do we sort of start arranging funeral and all that? What's going to happen? Some people can become quite angry. Why would you leave me like this? How have you sort of abandoned me? And they can become quite hostile in terms of their actions. So if somebody dies and then you tend to sort of visit the person, the reaction that you get will be different from different person. Occasionally, some people feel overwhelmed about what they need to do to sort things out. Some people will well feel that actually it's a relief, especially if somebody has gone through a long, protracted illness. Maybe the person had suffered and then eventually succumb to the illness and pass on. And the loved one will kids they've gone. And occasionally some people will have mixed feelings, which may be a combination of all this. Next slide. Right. Okay. So now it's becomes he has no motivation. He's feeling very low in energy. He's feeling hopeless. He's talking about feeling worthless, and he's talking about wanting to join Chidi in the grave. The week before, his wife had found 3 ropes that he had made. He studied those under his mattress. They found suicide notes in the bookshelf, and he had written to his wife and the other children. Mr. Kofo is worried and arranges for her husband to be seen by the GP, but Mr. Kofo refuses to go to the GP. So GP home visit and was shocked to see Mr. Okafor's presentation. He was severely depressed in mood. He had become pale. And because he wasn't drinking and eating well, he had become dehydrated. And at that point, he wasn't really expressing clear. He had become sort of having some thought about his intestine had become rotten, and that he could feel that he could smell his intestine being rotten. He had also begun to have thoughts that even though he was still alive. We call these nihilistic delusions. So GP just saw that this is a case of psychotic depression and thought that there needs to be an admission to hospital. But then again, Mr. Kofo refuses. So what do people think should happen now? So Kofo, he can't, he's very, I would think is psychotic as well, but he's refusing to go to hospital, he's refusing to go to see him.
Okay, yeah, Missy.
Yeah, I think in this he should be sectioned.
Okay.
Under the Mental Health Act, there must be some section in there where somebody is refusing, but they clearly, after psychiatric diagnosis or from the GP, that he definitely needs intervention, so he could be sectioned.
Yeah. Okay.
Yeah.
All right. Thank you very much.
Can I say something as well? Or chip in? On that note, yes, he might be showing psychotic symptoms. My understanding on it, and I'm talking from those who have a bit of experience. When I say experience, if the individual well, my understanding is that you can't force him out. If he's happy to go with them where they persuade, forcefully take it.
Okay. Okay, thank you. All right, okay, so next slide. Yes, okay, so, right, okay. So, it comes in, it's not careful. All right, so just a bit of and statutes. So over the years, as some lawyers in the House will know, that they became sort of governed by common law. So these are laws that have been made by over time. Over time, cases that then come, and then those laws becomes amended over time, and so on law. And then we have the Act of Parliament, and these are sort of laws that are made in Parliament that goes the King's assent before they become law, and they call them statutes. So over the years, the Mental Health Act, which had been, even before the one that we're using now, which is 2007, have been, brought about by a constellation of laws made. Now we have that governs what to do in terms of how you, you treat patients. And also, to an extent, the Mental Capacity Act. So in mental health, these are the two laws that we're really governed by. So the Mental Health Act itself is the law that deals with the right of an individual about the disorder and how they need to be treated. Whereas the Mental Capacity Act is a law unable to make decisions for themselves. And so if someone is unable to make decisions for themselves, the law tells you what you can do to plan ahead, or how you can ask for you, or who can make decision if you haven't actually planned ahead. So it's about someone's capacity. So in Mr. Okafor's law case, the two laws may actually be applicable, but there are reasons compared to the, and we may sort of have time to talk about that later. Next slide, please. Right, so what does the Mental Health Act cover? So it covers detained people in hospitals who are detained for wishes. And also detained individuals who are in hospital and also part of the criminal justice system. So we're talking about people in prisons who have committed a crime, but they've been transferred from prison to hospital, or actually people who have committed a crime and they haven't been to prison but mental disorder. It also sort of deals with the treatment of somebody who is detained in hospital or even in the and consent to treatment is part of it as well. It deals with when somebody is in hospital and they want to discharge them, how you deal with those people. It talks about the kind of treatment that you can provide for people in the community, like a community treatment order, and the rights of somebody when they get discharged from hospital, they're legally expected to have a package of care that's supposed to support them, which is called the Section 117 aftercare. And then it deals with their rights, family rights, and also thinks about the nearest relative. These are people that make decision on behalf of the family members that make decision on behalf of that person that has been detained in hospital against their will. Next slide, please. Right. So how about what are the rights? So if somebody were to be detained in hospital, do they have any rights? Yes. They have a right to appeal. So there's a right to appeal to the mental health tribunal, which is a court. They have a right to have an advocate for their case. They have a right to appeal to the hospital managers. They have a right to complain. They can vote like you and I, except for people who are being convicted of a criminal offense. They have a right to have visitors, to write letters, to make phone calls, and they have a right to have a care after being discharged. So the Mental Health Act itself is not only about detention; is a holistic law that ensures that if you're detaining somebody of their liberty, you need to ensure that you provide the right support for them. Next slide, please. Right. So now, detention itself, what does it mean? You hear about, someone has mentioned section. What does that actually mean? Sectioning means we're talking about the sections that are part of the Mental Health Act itself. Right. So in terms of Mr. Okafor now, who we has been determined to have a psychotic depression, who's refusing to go to hospital, and there's clear concern that he is unwell and he can't make decisions for himself. The process of sectioning somebody can vary depending on the section, but invariably, there's a need for 2 medical doctors to be part of that assessment, one of whom must be approved under the Mental Health Act. That is, they have experience with diagnosis and treatment of somebody with mental health problems. There needs to be also a social worker who will actually then approve mental health professional. Invariably, usually social workers, but they may not be social workers. Possibly 99% of the AMPs are social workers. And they are the ones that are actually doing the recommendation to detain somebody. So the fact that the two doctors are available and doing part of the assessment, it is the AMP that is recommending the detention. Now, the person's nearest relative can also be acting form of an AMP. They can also make a recommendation for somebody to be detained. But obviously you need two medical doctors as well. So, but I haven't actually come across a nearest relative being involved in a mental health act assessment. And there are reasons for that. You know, Mrs. Okafor will be thinking, actually, Mrs. Okafor doesn't want to go to hospital. For her to be involved as part of somebody detaining Mr. Okafor into hospital can be a bit, you know, can have relationship issues. So more often than not, they're not involved. But the act spells out that they have to be informed and they have to be part of that process. And depending on the section, they have to agree to it, and we may come to that as well.
Sorry, Doctor, I think Steve raised his hand.
Yes, Steve.
Thank you. Just a quick question. So on that last point about the nearest relative should also be involved, and you put in brackets, they're not the same as next of kin. So are you saying the next of kin's views on the potential situation could be overruled by a relative?
So the next of kin is not nearest relative. Now the act sort of specify who is a nearest relative. Then a next of kin can be a nearest relative, but not usually. So, I mean, this is usually what the AMPs, the social workers, or we say the AMPs, usually would have to clarify who is the nearest relative. It's usually, say, for example, the married couple, if it's a husband that is being involved in the detention process, it's usually the wife that is the nearest relative, and vice versa. Now, if it's somebody that maybe is a child, then the next relative may be actually be the oldest person. So it may be the father rather than the mother. Okay, if they have what they call parental responsibility or not, you know, so it depends on, there's so many tests that you need to go through to find out who the next relative is. So the AMPs are usually the ones that will find out who they are, but we just need to be sure that the next of kin is not the nearest relative, and the next of kin do not have any right to be able to overrule the process of the detention. Just to answer your question now, Femi. Steve, sorry.
Oh, yeah. Steve, can you like Femi ask this question as well in case it's related? Femi, please go for it.
Yeah, so my question to you is this then. In terms of capacity, which you've elaborated and mentioned, and how the law applies, and I'm talking this is from my own personal experience here, whereby the individual who is involved tells the professionals, be it the doctor or whoever it is, that they should, well, mine is that they should not disclose to the next of kin or even to the partner any information about their healthcare. My understanding is that as it stands now, that's what it is, that in terms of the law, it doesn't allow them to say, even though they might be sectioned, they might not have the capacity, but if they've given instructions that you shouldn't divulge any information to any other party, even the partner or the next of kin, that's the way it is, as my understanding. And please correct me if I'm wrong.
Yes, you're right. I mean, this is about capacity. So if the fact that somebody has a mental disorder does not necessarily mean that they don't have capacity to make a decision about, you know, sharing information about their health and those kind of stuff. So if, for example, you know, there's a husband
And that is even despite the fact that they've been sectioned and they've told them that, oh, they can't make decisions, that
Yes.
they're taking that decision away from them, somebody else, despite that.
Yes.
Okay.
Yes. So even
I find that to be odd.
Well, there are sort of clinical reasons and legal reasons, and one should be careful that you don't mix the two. So if somebody is saying confidentiality as well, so if someone say, I do not want you to share information with my wife, for example, even though the wife is a nearest relative, and then you have been able to assess that man, that husband, that they have capacity to make that decision, that is it. It has nothing to do with the act at all. You know, so this is about capacity issues and sharing of information.
Thank you, Doctor.
Yeah.
Okay.
Right.
Okay. Thank you. Okay.
Okay. So the next thing is that, okay, so we know.
Sorry, can I just quickly butt in there, please?
Yes.
If for any reason the husband now deteriorates, do they now share the information or still not share the information?
Well, I think if the husband deteriorates, if at the time when the person makes the decision, you know that they have capacity, they're very clear of what their decision is. That is it. Whether the deterioration becomes terminal or not, that's when they had capacity, they made a decision. That's the decision. You can't overrule that.
Okay, thank you very much.
Right. Thank you. Right. So, what is the test itself? Actually, before you can detain somebody, there are things that you need to go through to ensure that Mr. Okafor really needs to be detained. And we're going to sort of talk about the Human Rights Act as well, because it's important. If you're taking somebody's liberty away from them, you want to take them from where they are forcefully and put them somewhere else, that you ensure that you meet the criteria. And the first thing is that the person has to have a mental disorder. And the diagnosis of the test itself for mental disorder is not a clinical one, it's a legal definition. So somebody may have a mental illness, which invariably may mean that they have a mental disorder, but not necessarily so. And I think the reason why they do that is for people like learning disabilities. So they may have a mental illness that we know about, but they may not have a mental disorder, because that their learning disability has to be associated with other things as well, which we call, maybe they have seriously irresponsible conduct, or they are abnormally aggressive. And that would then tilt them from, say, they have a mental illness to a mental disorder, or maybe someone with autism and all that. The fact that they're autistic does not mean that they have a mental disorder. They have a mental illness, but they're not a mental disorder. So say, for example, Mr. Okafor now. Mr. Okafor has, we know that, the GP has diagnosed with a psychotic depression, which we agree with. That seems to be a mental disorder because associated with other things as well. Okay. So the first thing is they have a mental disorder. The second thing is that mental disorder has to be of a nature and or a degree that makes it appropriate for that person to be detained in hospital for treatment. So if you're not able to say that the mental disorder is of a nature or in a degree that will be appropriate for detention, then you can't detain them. Okay. So is it even necessary? Is this in their interest or their safety, or is it for the protection of other people? Now, these are all legal tests that you need to make sure that they abide with. Now, so if it's necessary and it's for their health, it's fine. If it's necessary and it's not for their health, it's not for their safety, it's not for protection of others, and they meet all these other criteria, then you can't do it. Okay. And then for some other conditions, some other sections, there's something they call treatability, which means that that person that you want to detain, they have to have appropriate treatment where you're taking them to. So you have to say that, all right, Mr. Okafor cannot be treated at home because of, he's suicidal, he's got delusions, he's not eating, he's not drinking, and all those kind of stuff. And where you're taking him to, there's treatment there available for him. If there's no treatment there available for him, and then you want to section, you may be able not to do it. If you're doing this, what they call a section 3. But if you want to admit to hospital for an assessment, then you could do it. But these are all legal terms that I won't sort of bother you about. But invariably, there are tests that you have to go through before you can detain somebody on a Mental Health Act. Next slide, please. I'm just mindful of time.
Okay.
Right. So, what are different sections? I've just sort of taken a few out of them so that, we can understand it. So there's section 135, which allows the police to enter somebody's house and take them from their house to a place of safety for an assessment. Now, and then there's section 136, which empowers the police to detain somebody they suspected to be having a mental illness in a public place. It has to be a public place. And there's definition for what we mean a public place. I think in some cases now, some case law are coming up now that some parts of your home can actually be regarded as a public place. But that's still, there are lots of arguments about those, but we won't talk about that. So 136, someone is in a public place, say for example, A&E, in a park or whatever, the police suspect that they may be mentally ill. They take them from there to a place of safety for a place of assessment. Section 2 is detention in hospital for up to 28 days, and that's for assessment and treatment. So for example, somebody that you don't know before, you don't know the history, like Mr. Okafor, if he needs detention, invariably they'll be saying maybe section 2. Now, section 3 is somebody's been detained in hospital for up to 6 months. Usually, it may well be somebody that you know about, the history, they've been coming back and forth, what the diagnosis is, but they need to be detained in hospital for treatment, and that's section 3. Next slide, please. Right, okay, so Mr. Okafor continues to refuse attending the GP or self-voluntary admission to hospital. He's referred to mental health service. Mrs. Okafor had traveled abroad for a family function while the 2 children were working away from home. The mental health team attempted a home visit on 2 occasions, but Mr. Okafor refused to open the door. A neighbor sort of sees Mr. Okafor, who they've asked to look after him, but they called the police because they noticed that Mr. Okafor was not living well. The food that's expired in the fridge, there's feces on the floor, there's urine on the floor. Clearly shows that Mr. Okafor is not coping by himself at home. What do people think that the options are for Mr. Okafor? Now, we've gone through some sections of the Mental Health Act. What do you think we might be able to do?
So, section 135?
Yes, absolutely. So section 135, which means that, and that can be done very quickly. It takes a magistrate to give an order for the team, the assessing team, and the police to attend Mr. Okafor's home and forcibly take him away from there to a place where he can be assessed. So 135 will be applicable here. Thank you. Next slide. Right, so just very briefly, so this is an assessment process. Now we're talking, I want to say, as part of the Mental Health Act also talked about consent to treatment. But consent to treatment in itself can be a separate discussion on its own. So what does it mean? It means that a person must give permission before they receive any type of medical intervention, whether it's treatment, a test, examination, investigation. They need to give you consent. And to give consent, an individual will need to have the capacity to do so, and they have to give it freely. Again, there's a test to be able to say, does somebody have capacity or not?
Sorry, yeah. Doctor, apologies. Just for my sake. You keep talking about there's a test.
Yes.
Who administers the test?
Okay. So the test will be administered by, say for example, right, the consent to treatment now. The test can be, it depends on who, or let's say consent in itself, consent to do anything. Mm-hmm. You want to do an examination for somebody. Say you want to do a rectal examination because they've got prostate enlargement and all that, okay? You cannot just say, Mr. X, come here and then put your finger down the top, the bottom. They have to be able to give you the consent to be able to do that. Mm-hmm. So the test is that, all right, okay, does the person have enough information to able to understand that they need a rectal examination?
Okay.
That's the first thing. Do they understand it? Can they retain that information? So you're asking them again, all right, and they can retain that information, right? And can they weigh the pros and cons of the benefits and the disadvantages of the test that you want to do? And can they say, yes, I'll agree to it? So those are the 4 tests. And the person that will do the test is the person that's administering that treatment or that investigation. So you wouldn't say that you need a psychiatrist to come and do a capacity assessment for somebody who needs a prostate examination, because it's not, so, but if it's something that leads to mental health issues, then you can ask a psychiatrist to do that. But invariably, a doctor, a nurse, a social worker, they can all do, assessment of capacity, depending on what it is that the question you want to ask.
Thank you. Thank you.
Right. And then to be able to if you then treating somebody or you investigate somebody or you're doing any kind of thing without them, that's against the law. You can be charged with battery. But in some circumstances, you may not need consent to treat somebody. And that is applicable with the Mental Health Act as well. So some people who are detained under the Mental Health Act do not invariably need, they have to sort of need consent to treat them. I mean, there are times when, and there's safeguards, because you can't just say they're in hospital, you just bombard them with anything without any safeguards. So there's something we call the second opinion doctor will have to sort of agree that, yeah, what you want to do is fine. And there are times in which after it's a lapse, you need to seek consent. You need to seek an opinion from somebody else if they have capacity to give consent. So they can either say, yes, I agree to sort of take my risperidone, I agree to take my antipsychotic, or I agree to the injection, or I refuse. If they refuse, depending on when they've been admitted, you can still treat them without the consent. But invariably, you may need somebody else, a second opinion, to agree with you. Right, okay. What other times do we not need? So somebody who lacks capacity, they don't have capacity, but you need to treat them in their best interest. So then, as we said, they fail the test. And the other time is when you have to give emergency treatment for life-saving measures. You can't be saying that you want to start looking for consent, but if they need life-saving treatment, you treat them and then you deal with consent later. Next slide, please. Right, so if you worry that you may one day lose capacity to make your own decision about treatment, you can plan ahead. This might include making what we call an advanced decision, an advanced statement, or lasting power of attorney. Okay, so an advanced decision, what is it? It's a statement of instruction about what medical treatment you want to refuse in case you lose capacity to make those decisions in the future, and it's legally binding. So you can think in 10 years' time, if I need blood transfusion for any reason, I don't want it, and you've made an advanced decision about it, and it comes to a time where, say, for example, the person then has a road traffic accident, the advanced decision is there. They need blood. If you cannot give them the blood, if they've got to die, that's it, because they made that advanced decision. So that's the treatment that they want to refuse. An advanced statement is slightly different. So these are written documents that sets out the preference, what you will like. So say, for example, say, well, actually, I would like, if I need to be in a nursing home, I'd like it to be a 5-star nursing home, that there'll be chef and those kinds of things. These are your preference, but it's not legally binding, because it is possible that when it comes to that time, the nursing home will not be not be a 5-star rating. It may be, somewhere that the council can afford. And those are your preferences, but it's not legally binding, and it's not about what you want to refuse. And last one is a lasting power of attorney, which is a document that lets you appoint somebody called an attorney, just so that when you lose capacity, they can make decisions on your behalf. And these are things that people can put in place, thinking about the future. Next slide, please. Right, so I did say that I was going to talk slightly about the Human Rights Act. And the reason why this is important is that the Mental Health Act, the Mental Capacity Act, they have to be in sync with the Human Rights Act. So the Mental Health Act cannot, you can't do things that will be in conflict with the Human Rights Act. Now, there are some articles, there's certain articles within the Human Rights Act that is very important in sort of in terms of the Mental Health Act. So, and that's Article 2, 3, 5, and 6. But what's the Human Rights Act for some of the lawyers amongst me? So that is it gives legal protection for basic human rights and freedom. And these are rights that cannot be taken away from you, although in certain circumstances, as we said, they could be restricted. So the important ones relating to Mental Health Act or to mental health is Article 2, the right to life, Article 3, prohibition of torture, inhumane or degrading treatment, Article 5, which is the right to liberty and security, and Article 6, right to fair hearing or a fair trial. Right, so Article 2, so it means right to life, not a breach. However, if that right is to protect somebody else from unlawful violence, or is to prevent somebody from escaping from detention, or to stop a riot. So in terms of the Mental Health Act itself, you're detaining somebody in the hospital. What the Mental Health Act does is if you detain them because you want to prevent them from, say, they're running away. Yeah. So that's why the act has been come into place. Or somebody wants to kill themselves, you know, you're doing some things in there to preserve their life. Okay. So the other scenario that I say, Adebisi is detained in a psychiatric hospital because they will risk that she will take her own life to harm herself. The hospital has a duty to protect Adebisi's life because it's a right to life. And that's part of things. What they do is that, okay, there's some areas in the room that they check to make sure there is no ligature points, that the windows are secure, that she's not able to leave and all this kind of stuff. So you can tell that that's the protecting her right, and at the same time preventing her from escaping. Next slide, please. Article 3, as we said, is prohibition of torture and inhumane or degrading treatment. So the kind of treatment that you have, or the treatment that an individual is provided with must not be seen or must not be classified as being a torturous or inhumane treatment. So another scenario that I've just put here is Richard is under Section 3 because he has schizophrenia. And then his doctor thinks that he needs to take antipsychotic medication, but that gives him some side effects. So an independent psychiatrist who is supposed to give him a second opinion about that antipsychotic that they want to give has to visit him and has to agree with the treatment plan. So the fact that the medication itself gives him some side effect, and you have done what you're required to do within the law to ensure that there's another doctor that gives a second opinion. So yes, I agree. On balance of probability, this treatment is in Richard's best interest. It means that you're not, the treatment is not inhumane, and that's fine. Okay, scenario 4, Kemi is trapped into a wheelchair for a long period of time to prevent her from wandering off the ward or the hospital. She's very agitated, she's very distressed. And the nurses were told that this could be degrading treatment because you cannot leave somebody strapped in a wheelchair for a long period of time without any intervention. So that could be classed as degrading treatment and it could be unlawful. Next slide. So Article 5, what is it? It's the right to freedom. Everybody has a right. So this is what the Mental Health Act itself, the detention, what is hanged upon, that you're depriving somebody of their freedom because you're detaining them, they can't leave. So this Article 5 is so important in mental health, okay, because it restricts people of their freedom. Now, but you can do that if it's within the law. That's why the Mental Health Act is there. Or if the police have arrested the person lawfully and put them in, in the cells, the Police Act and all this kind of stuff, pays.
Sorry, Doctor, apologies.
Yes.
Can I just say we only have like 10 minutes more? And
yes, I think
we're going to share these slides later. Yeah. Anyway, please go on. 2
more slides and then we're done, I think. Right, so Article 5, fees apply to a mental health tribunal, while it's on Section 3. Tribunal normally takes 8 weeks for the application to be made, but Kofi's case was not heard for 20 weeks. So what's going on? That's a breach of his human right. You can't do that. He has to have a right to fair hearing. So that means you're preventing him from living. Chizoba was detained on Section 3 despite her father, who was acting as narrative objecting to it. So as we're saying initially, that the role of narrative is very important. So if they object, you have to do something about it because then you need them as part of Section 3 detention. Scenario 7, John was discharged from section by tribunal, but there were long delays in him returning home to the community because there was no accommodation. And we find out in mental health right now, people are in hospital for a long period of time and they have nowhere to go. Again, this is a breach to his freedom. You have to do something about it. Next slide, please. And I think this is the last slide. So right to fair hearing. So anybody that's under the Mental Health Act has to have a right to their case being heard. Right, so if they're detained under Section 2, they can make an application within the first 14 days of their section. And in England, that case has to be heard in court within 10 days in England and within 7 days in Wales. But if they're detained on Section 3, then they can apply anytime within that first 6 months. But if they're detained for longer, then they have one more time they can apply within that period of 6 months. And if it's for 12 months, then they can apply once every year as well. So I think that's the last slide, and I thank you for hearing me, and I'll take any questions.
Thank you very much, Doctor. Really, really appreciate it. Let me stop the recording first before people then start asking questions. That's me.